SJC-13735, Commonwealth versus Elana Gordon.
Okay, Attorney DeMayo.
Good morning. May it please the court. Christopher DeMayo for Elana Gordon. I want to talk briefly today about testimonial, the testimonial status of lab notes and bench notes and worksheets and things like that. And then maybe say a word about the meaning of Smith v. Arizona for the use of substitute analysts. So before even getting into the substance of the testimonial issue, there's a question of waiver. I would submit that the court should consider. When I filed the brief a couple years ago, I raised the issue of whether this violated the Confrontation Clause. There was a discussion of what testimonial hearsay is and so forth, and the government's response was to say, well, this is all right under the Grenadier case, which is a fine response as far as it goes, but there was no mention of, and by the way, this isn't testimonial. So to make the argument now after it's come back on remand is sort of akin, I think, to making an argument for the first time in a reply brief. It's sort of saying a new thing that you could have said before. But I'll leave it at that. That's just an issue I want to flag for the court. In terms of the testimonial status, so in Smith, six justices agreed on a primary purpose test for whether something's testimonial. Justice Gorsuch would have used an even wider, more expansive test. So it's at least six justices. So you look to what is the primary purpose of the document when the person was making it. And I would suggest that here the primary purpose of lab notes when you're recording what your substance looks like, how much it weighs, things of that nature, is to ultimately generate inculpatory evidence for the prosecution if you're working in a crime lab and you're trying to identify a substance. I don't really see any other.
May I ask you a question?
Yes.
So there are two components to the inquiry. The first one is whether it's hearsay, correct?
Yes.
So is there a reason why you're asking us to look at whether it's testimonial before we look at whether it's hearsay?
Well, I consider the hearsay question sort of settled by Smith because it's an out-of-court statement. I can talk about hearsay.
I mean, it has to be inadmissible hearsay, correct?
Hearsay, as I understand, hearsay within the meaning of the Confrontation Clause, as opposed to any particular state's law of hearsay, is an out-of-court statement offered for the truth. Now, there may be some exceptions, like in the Davis case, where it was a 911 call. But the exception there, it wasn't because excited utterances are an exception of the hearsay rule. It's because it wasn't testimonial. So, as I understand it, really the question, hearsay is pretty simple. Is it an out-of-court statement offered for the truth? And if it is it testimonial?
What do you contend was the out-of-court statement?
So I have a two-part answer for that. So in my view, this is the broader view, which the court may not like, but in my view, the whole thing, the entire opinion is premised on testimonial hearsay. And therefore, and there's a lot of language in the Smith case saying that the problem we have here is that the substitute analyst who gave her opinion, it was propped up by a testing analyst who was not present in the courtroom, and you couldn't ask questions about what they had done or how they had done it or if it was to be believed.
What about the data results from the mass spec?
I mean, that's a piece of it that is arguably, I think the Commonwealth argues it wouldn't be hearsay because it's computer generated, but I don't think that's not going to retroactively change the testimonial hearsay nature of what came before it.
I don't understand what you're
Well,
saying.
I don't
that's like
either.
saying,
An expert comes in and says, I looked at the mass spec data results, And in my opinion, having looked at these squiggles on the test results, it's Suboxone.
Well, that's the equivalent, in my opinion, to giving a hypothetical opinion. It's like saying, if it were a chalk, does this mean anything to you? And you say, yes. If I were to see that in my expert opinion, that's Suboxone, but you've still got to lay the foundation that, where did that chart
I'm
come
the
from?
supervisor. This is what happened in this case. I looked at the data results from the mass spec, and you're saying that's testimonial?
Yes,
That
it may not be hearsay, but it's
all
certainly.
raw data is testimonial?
If it's evidence that is generated to create inculpatory evidence, our position is it's testimonial. Now, the government says, well,
Can you go backwards for a minute, because you're jumping to the mass spec, which is the confirmatory test. Can you just go back to the first part for a second?
Sure.
So the first part is simply, I look at the markings on whatever the contraband is. I go to some kind of a website to see if the markings are consistent with any particular known substance.
Yes.
And that, once that's done, okay, so this isn't the typical substitute analyst case, because the testimony here of I'm blanking on her name.
LaBelle.
LaBelle.
Yeah.
LaBelle's testimony is, I looked at everything the person that did the first round of stuff did, and I confirmed it. So if we just go in sequence for a minute. So there's a picture taking of the markings. That picture is then compared to some website. I don't know that we said that it's done here, because the testimony's a little bit, the testimony doesn't seem to support that, but I'm just making sure we're going in sequence here. If the analyst had taken pictures of the substance and the markings,
Yes.
and indicated in the notes, here's the website that I went to, are you suggesting that if a substitute, or confirmatory person comes and says, let me take a look at the picture, let me go to the same website and confirm that 2 + 2 equals, that somehow violates confrontation?
No, I think the photograph makes a big difference. And I think actually the Amici law professors, well, I don't know if this court, I don't know the status of that brief, but there was a brief was filed, and they make that point that you could. And a lot of this, there may be workarounds for a lot of.
There may be, but I just want to focus on your case.
I agree with that.
You would agree with that?
I agree with that.
Okay, so now with Justice Gaziano's point, what evidentiary value does it have unless and until somebody looks at all of the puzzle pieces and says it equals this? And if it's based on data that is just indicated on running notes about what they're doing, here's the substance, here's the piece, I put it in this solution, put it in mass spec, and here's what it says. And somebody who has the same level of credentials comes back and says, okay, there's the piece, there's the solution, there's the results from mass spec. Why is that not okay?
Because she didn't see it, and she doesn't know if it was actually done. She can certainly testify, and Smith says this, to what should be done, but what she says a little more. LaBelle says on page 31 that her job for Dunlap and other analysts is to make sure they had, quote, had taken every single step appropriately from first getting the item of evidence. She doesn't know that. She wasn't there. She didn't see it.
Right, so doesn't that go to foundation or as opposed to whether it's hearsay
No,
or testimonial?
That does not go to foundation because she's not there. As a matter of federal law, under Melendez-Diaz and Bullcoming, she was not there. She's not a percipient witness.
So you're saying she could not testify in a hypothetical form where she describes the lab protocols because she works in the lab, and then the attorney says, the prosecutor says, all right, if we assume that the drug was tested, that the drug tested that was put into the machine to produce these results was the drug taken from these strips of paper, what do these results indicate?
I think she could say that. I mean, Justice Kagan clearly says you can do hypotheticals, but the rub is you've got to actually bring in the fact witness to close the gap.
So, but doesn't that mean that her testimony as an expert and as a substitute examiner with respect to the lab results is fine? It just has only conditional relevance depending on whether the prosecution can link those results to these particular strips of paper?
Well, I disagree that it's fine, because that's not, it wasn't posed as a hypothetical. She said, I make sure they dot all the i's and cross all the t's, and.
Well,
she
I
did
understand
this.
there's a sentence where she says, literally, the original analyst put the strips into the solution. And
Right.
I'm not asking about that. I'm asking, because we're trying to zero in on what's the problem here.
The problem is, in my view, allowing a hypothetical does not get around the problem, because even in traditionally, as I understand it, this is before my time, but up until they had the Federal Rule of Evidence 703, and this court adopted it, you could pose hypotheticals. You could say, doctor, if somebody turned green and vomited and died, and they had spots on their liver, would you draw a conclusion? He'd say, yes, this is strychnine poisoning. But then you had to actually bring in the people to say she turned green and vomited and died. So same thing here. She could hold up that chart saying this is a classic.
So what we have here is I think it's pages 28 to 30 of the fourth transcript, where what we have in terms of trying to connect the dots is that she says this sticker number, I'm going to mangle the details, but something like she says identifies that there's a lab number on the sample. Is that correct? And then she says that this reflects that this sample came into the lab and was tested, and then she says it's the same number as the results that I looked at. Is that right?
I didn't make a big deal of that, because that seemed to me more chain of evidence. I'm not sure that's okay, because in the Williams v. Illinois case, there was sort of similar testimony about we sent the DNA off to Cellmark, and then this is the barcode or whatever, and I got it back. The dissent in Williams didn't like that. Of course, they were the dissent, but now it's been overruled, so I don't really know what the status of that is, but that's certainly an issue. There's sort of a preliminary chain of custody issue.
But isn't it not just a chain of custody? It goes to whether you're agreeing that the substitute could testify hypothetically about the meaning of the machine-generated results. And so the question is whether those can be linked using this substitute's testimony to the actual strips of paper in the case, right?
I'm not sure I followed that. I'm sorry. So her testimony.
Do you agree, I thought, that she could testify to the answer to a hypothetical question if the test strips here were tested and the results were this machine-generated result, is that this drug? You agree that she could testify to that hypothetical question, correct?
I agree that, I guess I don't understand the part about these test strips. I was asked, Justice Gaziano asked about, what about this chart here? Isn't that just like a computer generated? I agree that is, and that you could say that is the classic pattern of Suboxone or whatever. But I'm just.
So the question is.
So that's admissible.
Is that admissible? Well, it's not admissible because there's no.
It's a testimonial.
There's no foundation for it. I mean, until you.
How's there no foundation for it? I'm the supervisor. I went into the lab report. I looked at the data results from the mass spec, and you're saying there's no foundation for it?
Yes, I don't think there's any difference here between LaBelle and it happens to be her job to do technical readings, but she could have been an expert hired 2 years later. She has a chart. The question that.
Isn't your point more basic? I'm just looking at 16 in Smith versus Arizona.
Okay.
So from your review of the lab notes in this case, can you tell me what scientific method was used to analyze 26? Yeah, what was that? The microscopic examination and the chemical color test. That was done in this case. Yes, it was. I take it your whole argument is that's the same as what's going on here.
That's exactly the point, and I believe this.
And that, just let me close the loop. And then when Kagan writes, Rust's statements thus came in for their truth, no less because they were admitted to show the basis of Anjani's expert. That's your argument, right?
That's the argument.
But that's only as to hearsay, not to testimonial. She doesn't decide testimonial in Smith.
Well, that's true. That's why.
But that's not a small point. It's a big point.
Well, that's why I started out my argument talking about testimonial. But yeah, but yes.
You start out with the winner.
Well, it's clearly. I mean, it's here. The lab notes. There's no question. The lab notes. So if the question is, can we just take this chart in the abstract and ask a hypothetical question? Again, I don't think you can get there because you've got to lay the foundation, and the foundation,
You don't have to win that, right?
I don't have to win that,
Why
I
don't you
agree.
get to testimonial, because that's the hard part of this, and the Supreme Court hasn't decided.
Recognizing that that's where you wanted to start.
So, the waiver issue aside, if you look at, as I read it, so when she's talking about the person Dunlap did everything that they're supposed to do according to the process, we're a little bit of a disadvantage because we don't know exactly we can only infer, but it appears to me she's talking about, she looked at the weight. So there's some kind of notes or worksheets where she's recording this process that she went through in order to culminate in this mass spectroscopy chart, which will culminate in the ultimate opinion. So it's all one
It
continuous.
culminates in a final report. It culminates in a final report.
It culminates in a final opinion, I'm going to say, because that's what
Well,
LaBelle gave here.
you can
but-
disagree with that, but it culminates in a certificate. You know that from court.
So I don't see any reason, so if it's a primary purpose test, it's not clear to me what other reason there could be for going through the methodical scientific process of recording everything.
Couldn't it be for the purposes of allowing someone in LaBelle's position to conduct their technical review? And it seems like that's why it was done, and that's what LaBelle did in this case. Does that take it out of being primarily for a statement in court?
I mean, that could be a reason, but it seems to me the primary reason is to put the actual ultimate opinion on a solid footing so that when the defense attorney gets in there and cross-examines, there's some, you can't just say, well, you just came up with this chart out of nowhere. How do
Well, maybe with the first analyst, but Justice Wendland's point is more nuanced because you leave out one thing, and the part of the test is the objective purpose of it. So the testimony here from LaBelle is, I'm the technical reviewer. Everything that comes into this lab goes through this second technical and administrative review. So focusing on the fact that she's the technical reviewer in this case of this analyst, why isn't the objective purpose of what she's doing to satisfy the internal protocols of the lab to confirm every piece of evidence that comes in there for testing?
Again, I think that could be a reason, but I don't know that you could say that that's the primary reason. I think, as I understand it from what she's doing here, is just sort of the scientific process. I mean, from high school chemistry classes, and you make observations, and you weigh things, and then maybe you, at the end, type it up into a fancy report with charts. But so I agree that I mean, there could be a dual purpose, but this is, I mean, when people at the crime lab know when they're doing this work, it's not formal, it's not necessarily under oath, but it's a solemn kind of a thing. They know they might send someone to jail for a long time. It's a serious thing, and they are aware that it could be produced, it could be discoverable, they could be on the stand someday getting cross-examined. So from that perspective, it's all of a piece with this, getting to this ultimate opinion that you can defend in court.
If
which
we
is
were to
inculpatory.
use this line of analysis that you're giving us, how would you distinguish a piece of paper on which the steps in a chain of custody were recorded?
How would I guess I would distinguish that just on the basis that Justice Scalia at some point says, I think in the Davis
Crawford.
case, one of them that you know, not necessarily going to have to call on everybody who ever put their hands on. I think he's responding to a dissent by Justice Breyer.
That was both coming.
Yeah, and that could go to the weight of the evidence. He leaves that open. I don't really have a position on that because that wasn't.
Can you tell me how you distinguish the data results on the mass spec from a photograph and an autopsy?
Well, a photograph and an autopsy. You could have some, I mean, if it's 50 years old, you have to lay the foundation for it, so you could have some trouble, but I think generally you get someone, hopefully, who can say this is what it purports to
You know,
be.
the same, it doesn't matter if it's 50 years old or not. Same type of independent reviewer.
Well, it does matter, because it might be harder to find somebody to say that. I took that photo, or I remember this autopsy, and I
So
was...
you say they're the same thing.
I'm saying that in either case, yes, I'm saying that even if, and the photo is certainly non-hearsay, I agree with that, but you've got to lay the foundation, and I guess
No, we're talking about testimonial. Stick with testimonial. How, on the testimonial analysis, is a photograph and an autopsy the same as data results in a mass spec, in your view?
But my point on the photo, I'm agreeing with you that the photo is not testimonial hearsay because it's not hearsay. I'm not saying it's not testimonial. If the photo was taken, if it's foul play is suspected and they're doing an autopsy and they have a particular defendant in mind, then I think it is testimonial. But you get to rely on it if you're a substitute medical examiner because it's not just a photo.
So all these test and results cases turn on whether they have a suspect or not when they do the
No,
analysis?
I mean, it definitely turns to some degree on whether foul play is suspected because that's the Supreme Court's test. They say whether it's made with an eye toward creating prosecutorial evidence or with an eye toward court. So that's their test, not my test. But that's an issue. But I mean, there's all kinds of photos.
Sorry, go ahead.
No, I'm done.
Has the circuit, since Smith, have the federal circuit courts come to any consensus on this type of stuff, or do we still have this kind of open field running going on?
I couldn't find anything. I did a little research in the last week.
Post-Smith, we don't have a bunch of circuit court decisions yet?
I didn't see any when I looked, so not that I'm aware of. I just want to say, I mean, getting back again to there's a whole range of non-testimonial hearsay that people can still rely on. So not just photos, but x-rays, physical evidence, pathology slides. So this is really dealing with a kind of a narrow.
Could you go back to Justice George's? It seems like the most analogous is the chain of custody. Can you just walk us through again what the rule is on chain of custody? Is it considered testimonial, or if not,
Well, I don't know that there's a lot of developed law on this because, like I said, it was sort of an issue that was flagged and set aside as I read it. And I haven't read all the Federal Circuit cases, but I know it was flagged and set aside by Justice Scalia when he said, that you don't traditionally, you don't have to call everyone who's ever touched it, and that might go to it might go to the weight of the evidence. But that seems to me there's a very different. It's a very clear difference to me between somebody who's the cop who's handling a sample of tissue or DNA or drugs and the actual analyst who's ripped it open and is doing the work at the bench. So I see a clear distinction.
And can you articulate what that distinction is?
I think it's she's actually working with the substance.
Okay, just
At
so
the bench.
the work performed makes
yes.
a constitutional difference.
Right, I mean, at a certain point, because to the extent the substitute is relying on her work performed to give her opinion, that makes a difference. Now, of course, if you go further back in time, there's a chain of custody, but you have to draw the line somewhere, and as I understand what Justice Scalia is saying, that could be a point where you draw the line. And it's kind of intuitive that you're doing tests with reagents. It's not the same thing as
It's still, though, I still am trying to fine tune your position here because this isn't a situation where LaBelle comes in and parrots what the person said before. So the issue that I'm having is all of the stuff, if you've got the bench notes and you analogize this back to high school chemistry, where they're doing and they're recording all of the notes, everything that they're doing. And so the process here, it doesn't become relevant until they've analyzed and interpreted it. So if you've got somebody like LaBelle who takes the same notes and sees what everything that is done here, and they observe what they took pictures of, what they put, the solution that it was put in, And they've also, like she testifies here, that they're familiar with the protocols of the lab. Independently coming to a conclusion to you is still testimonial hearsay?
Yes, I don't think it's not independent, I guess is my point. And I mean, some of these tests are like, I put a drop of reagent on the suspected crack and it turned red, therefore it's crack. So if you write that in your notes, turned red, cocaine positive, if that's what they're reading, is that an independent opinion? I mean, that seems kind of a farce to me. They're reading what she wrote and they're saying, I agree, I've reviewed the file and I've come to an independent opinion. It's just, it is parroting. And I also disagree that she didn't parrot what Dunlap said, because, I mean, when she's saying that she put it in methanol and used I mean, she's not quoting her verbatim, but she's saying what she did.
I don't mean to oversimplify what you're saying, but it sounds like you're saying, okay, these notes reflect what she would have testified to if she were put on the stand, if she'd come forward. She would have described the steps in her process, right? I mean, I take it, is that what you're saying in there?
Yes, I mean, I think that, and that's, again, getting back to Justice Kagan, she said the person whose work product propped up the substitute's opinion wasn't in the courtroom and could not be examined about what she did, how she did it, and whether it's to be believed. Now, the Supreme Court certainly understood that Smith could have had his lawyer say, well, you weren't there, were you? And you don't really know. So that's clear, and they knew that, but they're saying, as I read it, that's not enough. You've got to get to, you know, were they lying? Were they incompetent? Things that you don't know unless you get at the foundation.
Chief, can I ask one more question? Sure. So what if LaBelle did not testify that Dunlap had put the sample in a particular methanol solution, which to me seems to be the only thing that comes directly from the notes? Does it make a difference in our analysis if those notes never were introduced, orally read, or, you know, because that's different than Smith, right? Smith, the notes were actually introduced, the report was introduced, and then the expert read, essentially, from those notes and report. Here, assuming a different case where the notes were not read in terms of the methanol solution, would that make a difference in terms of whether LaBelle's testimony was proper?
So I think we win either way, but I guess what I'm arguing, so I'm arguing two things. I'm arguing, as I read all that language that we've been talking about from Smith about the analyst the testing analyst isn't there, you can't get to the basis of whether she was incompetent or lying or whatever. That to me suggests there should not be any substitute analyst opinion that is based on testimonial hearsay. It can be non-testimonial hearsay. Okay, that's my broad argument. My more, so I think that was one error here. The second error was when she said those things. It wasn't just methanol. I mean, when you say I made sure she had taken every single step appropriately from first getting the item of evidence, that's just like in Smith. He said the same thing. I looked at it and he complied with our lab protocol.
All right, let's
Okay,
just
so
say
that's
that the real DYS standard, right, where you don't actually get in on direct the facts and data that have not yet been admitted.
Right.
In that hypothetical scenario, let's assume LaBelle testified that way, and she just said, I come to my conclusion that's Suboxone. And then, dear defendant, go ahead, try to cross-examine me on the facts and data.
Well,
Would that be okay?
No, like I just said, I don't think that's
Well,
okay.
let's just assume that your broader reading of Smith is wrong.
Oh, okay, all right. So if my broader reading is wrong, and she just takes the stand and gives her opinion, which is kind of, I mean, you always see these Grenadier violations because it's hard for...
But let's assume
yeah.
this ideal world where it's possible.
No foundation, she just says, I think it's Suboxone.
Right, and the defendant hasn't objected to foundation, so it comes in.
Yeah, I mean, if I'm wrong on the bigger argument and the opinion is okay, and also if she fails to act as a conduit, those are the two things. So then, yes, that would be okay under those. But here, I think both things. I think she kind of smuggled in the opinion She kind of smuggled in Dunlap's work product by giving her opinion, and then kind of to compound the error, she said those things about following protocol and about, you know, the markings on it and the gas chromatography.
Can you tell from the transcript whether that LaBelle actually herself looked at the markings? There was no photograph, right? Not like...
As far as I know, not. I thought it was kind of ambiguous. It's the way I read it is LaBelle said that Dunlap had printed out something from drugs.com. So I read it as she's looking at a piece of paper from a printer and not...
But she also says she looked at the pharmaceutical ID. LaBelle did.
Well, I took it to mean that's what the piece of paper was. I don't know. I mean, it wasn't clear to me that she went back to the vault and got a strip of the substance and compared it. And it wasn't clear that there was a photo, although that would have been a pretty good idea. But
Just one small clarifying question. I think you referenced this, but I wanted to be clear. Is it the case that you have not seen what LaBelle had, the notes she had, or the report, or whatever she had when she was testifying from the original analyst? Is that...
I think the report may have been produced in discovery, just one of those kind of standard report. The actual notes I could not find. I'm not prepared to say that they weren't produced, but when I looked for them at some point, I didn't see them.
Well, but do we even know there were quote unquote notes as opposed to the thing that was produced in discovery?
Well, I think she refers to them as notes in here. That was my basis. No, the thing that was produced in discovery, I'm going on my recollection. I haven't looked at it, but I seem to recall one of those drug.
But it's not in the record, but in front of us.
The record in front of us wasn't a trial exhibit. As far as the actual notes, I don't know that we've ever seen those.
Okay, thank you.
Thank you.
Attorney Hanson.
Thank you. If it pleases the court, Arne Hansen for the Commonwealth. I would ask that you deny the defendant's appeal. There is no confrontation clause violation here, the test for which is a two-part test, testimonial hearsay. Now, with respect to the substitute chemist's testimony here, it can be broken down into two separate parts. She testified about what was done in doing the analysis, and then she testified to the conclusions of the analysis. So I'll start with, she testified to how they got to the results. So she testified about the original analyst's work and how she prepared the sample for testing and then put it into the mass spec machine, which is a computer that then breaks everything apart and then prints out the result.
How is she competent to testify as to any of what the analyst did when she wasn't looking at the analyst over her shoulder?
She was referring to the case file.
So the notes.
Correct.
So essentially she's reading the notes to the jury. Is that what you're saying?
I don't think she was reading the notes to the jury.
Well, she's
She was
conveying the contents of the notes as to which she has no personal knowledge to the jury.
correct.
And that's a problem, isn't it?
No, it's not.
Why is that not a problem just based on our decision in DYS?
So Smith states that,
No, DYS. I'm at the evidentiary level.
I'm not familiar with that case.
Ooh.
So with respect to Smith, it states what Smith changed is testimony about how the testing was conducted is hearsay. What it fails to answer is whether it's testimonial. It gives the third section of
That's
Smith.
the second part.
Correct.
Don't you lose on the first part of this? Because we don't use state evidentiary rules for determining, hearsay. Is the statement being introduced for the truth? So when she says, the substitute analyst says, so the first test that the analyst performed was a pharmaceutical ID. I believe they used drug.com, but I can double check. And then there's another statement like that. Aren't those statements being introduced for the truth? And I don't see how you win the first part of this.
I see how you may win the second part, but I don't understand how this is not meeting the definition of Smith, that this is statements being introduced for the truth, that these tests were performed.
Yeah, so that's what Smith holds, that those are in fact hearsay statements, but the other side of that is because she's relying on the notes.
So just to right-size the case, the Commonwealth's position is that this was hearsay.
Yes, that's what Smith holds.
Okay. Well, Okay, and that's your position. So the question is now, is it testimonial?
Correct, and Smith doesn't make a decision because it wasn't in front of
But
the
what's the
court.
Commonwealth's position? Was this testimonial or not?
It's not testimonial.
Why?
If you look at Smith, they say, we're not going to answer the question, but if we do, this is what we say. And they say these notes are prepared for reasons other than the actual conclusions.
Where
They're-
in the record does it show that these notes, the ones that Dunlap took, were produced for reasons other than her preparation to testify at trial at some point down the line before she was gone?
At the start of her testimony, LaBelle gives a substantial amount of testimony regarding what her responsibilities are as a supervisor. She lays out what the administrative and technical review are and says, I do this to ensure that all of the steps are taken.
And why does she do that?
I'm not sure I understand. To assure that all the practices, like that the analyst did everything correctly to make sure that they were adhering to the lab procedures.
What is the purpose of this lab
It is to test drugs.
for the police?
Correct.
So to testify eventually before trial, right?
Yes.
So the whole purpose of this lab is to create evidence that will ultimately be introduced to trial, at trial.
Yes, but there is
So
a
the technical review is also part of that process, to make sure that the data analyst is actually doing what the data analyst should do.
yes.
Okay.
But if you look at Smith and then Bryant as well as Melendez-Diaz, they make a very clear distinction between what is testimonial and what is not testimonial. What is testimonial, and Melendez-Diaz makes this very clear, are the drug certificates. So those are signed
Right, but it doesn't say
attestations.
the notes are not. It just happened to be what was in Melendez-Diaz was the certificates. But it didn't say, oh, and let me in dicta decide whether or not the notes that support this are testimonial.
You are correct. So Melendez-Diaz came out in 2008. So then in 2011, Bryant came out after. And Bryant is the case that says the notes aren't testimonial. It says that they lack the amount of formality that is required to make this testimonial. There's a difference between the notes and the actual signed attestations. Bryant makes very clear that the signed attestations are what is testimonial. And then Smith builds upon that. And
Know she's going to track those notes. Again, if the original analyst had testified, she's likely to make all these points when she testifies, right? But it's still not, and she would have, it refreshes her recollection, she knows what she's doing. And again, it's not testimonial. It just seems counterintuitive to me. And the reason is because it's not the formal conclusion of the process.
correct. And
Even
that's
though
what
the
Smith
note
holds.
states the conclusion of Dunlap.
I'm sorry?
So the notes, as I understand, and I don't have them, but as described, they state Dunlap's conclusion at the end.
Yes.
There's not a separate certificate.
No, but that's the second part of the analysis. The second part of the analysis is the conclusions. Now, the conclusions were drawn independently by the supervising chemist.
There is a separate certificate, right? That's what, after the notes are taken, after all the work is done, and there's contemporaneous
Yes.
bench notes, a certificate a la Melendez-Diaz is issued.
Correct. But that wasn't introduced into evidence here.
Right.
And that would have been attested to by the original analyst. That was not replicated by the substitute. Now, with respect to the actual conclusions, what happens here is they put the drugs into the computer, and the computer generates data, which was analyzed. So that's raw data, which doesn't imply the hearsay portion of it. So that data could be construed as testimonial. There's an argument to be made that it's only the signed attestation, but the data is arguably testimonial, but it's not hearsay. So it fails the other portion of the test. Because it's computer generated, it doesn't.
Well, the results might be computer generated, but garbage in, garbage out. So how can we segregate it from what is the data that's used to be put in, which LaBelle had nothing to do with?
So there's two things here. One, there was another independent test done where she reviewed the actual markings on the labels and concluded based on those pharmaceutical markings that it was Suboxone.
No, she didn't. Because the testimony, so now you're conflating two parts. I'm not talking, you're talking about the stuff that was done with drugs.com. I was just asking you a question about the mass spec test. But even if you go back to the drugs.com analysis, when she's asked on direct examination about that, she refers to what Dunlap did. She doesn't say, I independently did anything.
So if I may read from page 34 of the transcript. The second cue down starts, okay, when you did the technical review, did you review the identification markings? Answer, yes, I did.
If you go backwards, this is where I'm going, okay? So this is the part that, the page right before. Okay, as it relates to the specific case, did you perform any technical review on that identification marking? Answer, yes. So the first test that the analyst performed, and she goes on to outline what Dunlap does. The question to her was, did you do that? And then she goes and she answers in terms of what Dunlap did.
Yes, I agree with Your Honor's interpretation of that statement on page 33, and I think as a point of clarification, the ADA asked that question again on page 34 and said, did you actually do this as well? And she said, yes, I did.
You're reading that into, did you review the technical identification markings, which then has to be compared to some known website?
Correct.
All of that is baked into that answer for you?
That is how I'm interpreting it, yes. I agree with Your Honor that a follow-up question, given the context of this appeal, would have certainly clarified that for the court, but we don't have that. But I think the purpose of that question, that follow-up question, is to assure and put in front of the jury that she actually did that review independently as well.
So that's just this screening test. Based on that, she can't conclude it's Suboxone. She has to do the confirmatory test,
Correct.
and she didn't do that.
No, but she reviewed the procedures that were followed, and then I think it's reasonable to infer here is what we have is a computer. If you don't put the information into the computer, it's incapable of doing the test. So, and I think this is a very simple procedure. She testified that she took a piece of the Suboxone strip, put it in a solvent, and
Right,
put
but she doesn't know that.
But that's
LaBelle,
what you-
LaBelle doesn't know that, and we don't have Dunlap to cross-examine.
Yes, that's fair, but I think the fair inference that can be drawn from this is without doing that, you wouldn't have data. It wouldn't.
Well, she did something. Did she do it right? I don't know. Nobody knows, because Dunlap's not here to tell us.
That's fair.
Right. And isn't that unfair to the defendant?
No, because that portion of it isn't testimonial. It's the two-part test.
She's getting this from the notes. I thought you just agreed the notes were testimonial hearsay.
No, I'm saying that the notes were hearsay. I'm saying that the notes are not testimonial. So there's a distinction.
I see. So you're saying the notes are not testimonial because of some statement by the Supreme Court in...
Bryant as well as Smith.
Okay.
Can you address, please, in light of the awkwardness of us deciding whether notes that we can't see are testimonial, the waiver question raised by the defense?
So I'm not entirely sure how I understand the defendant's waiver argument because he applied for further appellate review given a more recent decision by the Supreme Court who then outlined what the analysis should be with these cases moving forward.
I thought this is here on GVR. We just took it sua sponte from the appeals court.
Right, but essentially, he appealed it further to the Supreme Court, who sent it back to this court for further proceedings. So I think clairvoyance applies here, where the Commonwealth, nobody knew that a year later the Supreme Court was going to issue a new decision outlining how these cases should be analyzed, and essentially changing the law saying that these notes are actually hearsay, whereas every court has treated them not as hearsay up until that point. So there was no
Have
real...
we treated them as hearsay?
Prior to Smith? I don't believe so.
I think we have. If you were familiar with DYS, you'd know that.
DYS, Grenadier.
Right.
And have you done any research post-Smith? Is there any action by the Circuit Courts of Appeals that will be helpful to us? Any analogous situations where parts of things are testimonial and other parts aren't? I'm trying to think of maybe the domestic violence area or something. Anything that we can turn to for guidance here? Or are we writing on a clean slate?
I haven't seen any decisions that have come out since, and I tried to find the results of the State v. Smith case when it was remanded back, but I don't believe, I couldn't find the case.
So they haven't done it yet? They haven't.
I believe that decision hasn't issued, or at least I couldn't find it.
Well, there were state court cases, and there's, I know you might not know, but the distinction that you're drawing seems to be where those other folks have taken the puck, right? So drawing this distinction between the work leading up to what goes on the other side of the equal sign. So the notes, the photographs, the bench notes, whatever it is, but the ultimate conclusion is the part that they attach the testimonial component to. The stuff leading up to it, say, is non-testimonial. But you said that earlier, but I'm trying to figure out, are you collapsing the testimonial analyses to whether or not it has evidentiary value?
I'm not sure I understand Your Honor's question.
So if you're saying that all of the stuff that leads up to an analyst saying it's Suboxone, right? The mass spec, the solution, the strip, everything leading up to, and then he prints out the printout, and in the report says, and therefore it's Suboxone. But all of the stuff leading up to it, you're saying isn't testimonial. It would be the conclusion that's testimonial.
Correct.
So what I'm asking you is, are you then saying that the testimonial analysis only comes down to whether or not the test that's performed has any evidentiary value down the line at trial?
Yes, I think that's fair.
So if it comes out that the test says it's not Suboxone, you're saying that that has no, that means it's.
Yes, the test results are
Okay.
what is the purpose of creating this data is to prosecute the case. And you have to respect what the test results are. If they're not Suboxone and it's something else, then obviously, and it's not charged under the correct statute, you wouldn't be able to move forward with that prosecution.
So I guess I'm still confused because Justice Wendland's point was, this is what this lab does. So how can all of the stuff that leads up to the conclusion be accepted out of testimonial categories? But if it turns out that it is, and they're going to introduce it, that somehow magically transforms it.
Because I think the Smith decision makes clear, referring to the Bryant decision a decade earlier, that there's a distinction between the attestated to reports and the drug certificates and all of the lab notes. The lab notes exist to facilitate the internal review, as well as quality assurance, and to make sure that your lab stays accredited, to make sure that you follow the correct procedures. The court in Smith is very clear that the primary purpose of this is not testimonial. What is testimonial?
They completely don't say that. We note only that before the court can decide the primary purpose of the out-of-court statements introduced, it needs to be determined exactly what those statements were. It doesn't provide us guidance. It just says basically they punt on this, don't they? They haven't done what you're saying.
They haven't, because they remanded it to determine whether it was testimonial or not. So they completely punted on it.
No, they didn't make a decision, but my memory of reading it is that they state the purpose of these documents is for internal review and quality control.
Where did they say that? I'm just looking at it.
I think that the statement by those who joined that part of the opinion was that if these notes are for those purposes that you just delineated, then they would not be testimonial. They don't say that across all labs, lab notebooks are not testimonial.
So I have Alexa's printout here.
Why don't you read what you're...
The United States as an amicus curiae notes, for example, that lab records may come in being primarily to comply with laboratory accreditation requirements or to facilitate internal review and quality control. Or some analyst notes may be written simply as reminders to self. In those cases, the record would not count as testimonial. So that's page I think it's 35, the start of page 35.
Right. So they're saying we don't know the answer to whether it's testimonial or not, and send it back for you guys to kind of puzzle that out. But you're using it as an affirmative declaration that we can then take and say, look at everything that LaBelle testified to. It's all in keeping with the internal protocols and the accreditation of the lab and yada yada. How do you get there from that?
Well, I guess the Smith court makes clear that it's giving guidance on the issue and it's not setting a precedent. So I would say,
I don't know that they're giving guidance, particularly a week ago, they declined to take another case where they could have given guidance, and both Gorsuch and Alito said we need to give courts guidance on testimonial versus non-testimonial. So we're still up in the air looking for help from you.
okay.
So you say that there's no substantial risk of a miscarriage of justice here? Is that the government's position, if assuming that there's a confrontation clause problem, or?
Yes, because this was never at issue. The defendant's defense at trial was knowledge and
But
intent.
why do you, before we get to whether or not there is, why do you think that that is the right standard of review? The defendant raised at the end of Ms. LaBelle's testimony that this was a confrontation clause problem.
So with respect to the testimony, I think it's on page 24, 25, when the expert is going to take the stand. They approach the bench and they say, Your Honor, I just want to make you aware that this is going to be the substitute analyst instead of the actual analyst. We didn't file a formal motion because we're in agreement. So that, to me, suggests there's no objection from defense counsel.
But it was conditional, because the judge said, this is going to be independent, right? And the prosecutor said yes, and then they proceed.
Yes.
Right, and then at the end, the defendant at a sidebar says, I move to strike this whole witness's testimony. She conducted no independent tests for the items. I thought that she was going to.
No, and
And the
that's,
judge actually says, your rights are preserved.
that's fair, but he acquiesces to, the judge pushes back. And so
Well, the judge doesn't strike the testimony, but says, but your rights are saved on that issue, the issue of confrontation clause.
So that's certainly a fair analysis of the way that it went.
So
in.
assuming that the standard of review is not, as you suggest, substantial risk, was the defendant prejudiced here?
No, so the other standard would be harmless error beyond a reasonable doubt. And that's still, I think the analysis here still survives that standard. The defendant's defense centered
Well,
around...
if the defendant was able to keep out Ms. LaBelle, then no evidence of Suboxone. How is that harmless beyond a reasonable doubt?
Because we take the cases as they were tried, not how they could have been tried given different circumstances. The
But he
defendant...
tried to get the testimony out.
But if you look at the opening statement, it's very clear that the defendant's defense is she had no knowledge of what was in those envelopes. So therefore, she didn't have the requisite intent to transfer these drugs.
It really wouldn't matter what the defense was, wasn't it the Commonwealth's burden to prove the nature of the substance to sustain the charge of unlawfully delivering a Class B substance to a prisoner?
Yes.
So if the expert's testimony was impermissible, how would that have been achieved?
Oh, yes, that's fair.